Good afternoon. Welcome to the Business Forecast. We've been away for a while, but we are back. I'm Nikki Larkin. I'm the founder of Gorringe Accountants, and I have with me today David Stanners. Hi, David.
Hi.
And David is an expert in IP, intellectual property, and co-founder of 50 IP. So what we are going to intend to do for the whole year and for today's session is to go through various subjects that are really essential for your business, regardless of whether you're intending to continue growing your business for another 20 years or whether you're looking to exit your business. But key things that you should be looking to make sure that your business has got solid foundations for. And today is intellectual property. Hi, David. So, if somebody's not thought about intellectual property before for their business, what should they do? Where should they start?
I think my recommendation is always to consider what's the most important aspect of your business that you do not want someone to copy. If you're going to produce a product or a service or a brand and an identity, there's always a risk that someone can piggyback on the back of your hard work. If that's the case, the number one question is, can you keep it a secret? And if you can't keep it a secret within your organization, and that's not possible with a brand, but it is with a process, not so much with a product, because products can be reverse engineered, then register the intellectual property in association with that aspect of the product or the process, and certainly with your brand, if that is possible. It's
Fabulous.
important. Yeah.
So I just wanted to, if somebody hasn't listened to this before and you are watching live, whether it's on YouTube or LinkedIn, just want to let you know you can post questions or comments, feedback to us live, and I will try and include you. So just a reminder, so you should be able to in your comments and it should filter through. Super. So you were telling me earlier about that you've got sort of 5 stages that you look at when you're considering. So do you want to talk about the start of that?
Yes, I suppose for me, intellectual property starts with an idea or a concept, whether it's a name or a product or a service, as I mentioned. And it's essential that those products or services and the associated registered IP actually have a connection to your bottom line. IP should be seen as an asset and included on your balance sheet and treated with respect, just like some capital investment in a piece of machinery. The kind of 5 stages in my mind are, when approaching intellectual property, always consider a kind of map the scenario, map your situation. If you have a new technology, understand who your competitors are, what they might be protecting, what's valuable in the field. And if you're planning to launch a business with a new identity, or you have an existing identity that you wish to protect, it's wise to check who already has a trademark registration. You might find that the name that you want to use is descriptive and not protectable. It might have a hidden meaning or a double entendre, which is often the case. It's very common that words in one language mean something in another. You need to be very mindful of that. And yeah, just understand your position. So that's stage 1, to map. Stage 2 is really to decide what you want to do and protect. So when you come to stage 2, which is planning, make sure that you take that information that you have about your competitors in the landscape and decide, how am I going to get from A to B? How will I convert and protect my idea into some kind of valuable protection that means my investment is protected? You know, with a protected investment, you're in a much stronger position for exit. You're in a much stronger position for investment. If you're not protecting your business, then you're going to look weak. The third stage, once you've kind of mapped and planned, is really to build that IP portfolio. You start with some registrations, file patent applications, trademark applications, register logos, taglines, whatever you think is associated with your business. And then when you have that that build, that IP portfolio, it's not just something that you should file and sit on the shelf and keep sponsoring for the rest of its viable life. You need to make sure it fits your business, just in the way that you would develop a commercial property. You build it, you fit it out, you adjust it for the needs of the occupants. And similarly, your IP portfolio must be adjusted for the needs of your business. You might have started off filing something quickly because, oh, I'm going to a conference, I want to get this on file so I'm protected. You might go to the conference and find out that your idea is useless or has been done before, and you don't want to continue with that registration. You want to drop it, save yourself some money. So make sure that whatever you have on file is fit for purpose. And I suppose the last stage, stage 5, is to kind of exit or monetize. Do you want to license? Do you want to mortgage? Do you want to cross license with competitors in the event that there's some conflict or infringement risk? So there's a kind of whole idea to exit or idea to monetization. There's an IP thread that runs all the way through your IP activities in relation to your business, because they're an essential asset. And unless you actually diligently make sure that you're mapping and planning and building and fitting and monetizing that IP, you need to question what's the purpose. And everything comes back to this return on investment. You wouldn't buy a piece of kit or buy a new PC. You wouldn't do anything for your business unless you knew it was going to give you something in return. Intellectual property isn't always necessarily tangible in the sense that you can see it, you can touch it, or people appreciate it or understand it. But in some industries, it's essential. And to be honest, trademarks are essential in all industries and businesses.
So that's really good to understand the process: mapping, planning, building, fitting, and then monetizing. So going into a little bit more detail, what sort of things, if I was thinking for a business, what sort of things should I be thinking about that I should be protecting?
Well, there's 5 types of IP:
Mm-hmm.
patent, trademarks, designs, copyright, and know-how. Perhaps know-how is maybe the most undervalued. You know, know-how is really to be there if you cannot protect with a registration. That's where a good patent application or a trademark application comes into play. There are unregistered rights that subsist automatically. You know, your copyright, some design rights, some rights in your brand, in the sense that you can stop someone from passing themselves off as your business or the way in which you present your business. But the key focus, which doesn't require the same level of proof of copying, is patents and trademarks. Patents focus on technical get it right the way around, technical solutions to technical problems.
Mm-hmm.
That's really the essential test that I'm always looking for. And that can be an improvement of a product or a process. In relation to trademarks, it's about your brand and the identity that really represents you and your business. You know, whether it's a kind of Coca-Cola, the Coca-Cola TypeScript, or a Starbucks type situation where you're looking at an image that immediately draws recognition and adds value. You know, you could buy a cup of coffee from any shop on the high street, but Starbucks will be just that little bit more expensive because it comes with that reputation. And similarly with technology, if you have something that's new and inventive, then there's a probability that you can get registered patent protection for that solution to a problem.
What about so often people see in their contracts going about the things that you've created whilst you're in a business becomes the intellectual property of that business. How true, and this is probably verging onto employment law rather than just in IP, but how true is that? Or how can that actually be implemented? Or is that just trying to scare people?
No, it's not trying to scare people at all. I don't want to delve too deep because many countries have their own laws in relation to their own inventors. So, for
Hmm.
example, in the USA, if you had someone from the US in your team, you would have to file first in the US PTO in order to meet their legal requirements. And if you don't, they're quite punitive with respect to how they treat you. I've seen it happen and been involved in cases where you're trying to dig yourself out of a hole. In the UK, the rights to an invention start with the inventor. By law, your invention is automatically owned by your employer, but this is best to be reinforced within an employment contract. Now, that applies if your invention relates to the business in which you're in. You're working in the field of accountancy, but if you to invent a new brush and pan that was perhaps automatic or something robotic, then your employer wouldn't have the rights to claim that invention for themselves. But it's kind of quid pro quo. If you're working for someone, they're paying you to do something, then they're kind of entitled to own the output that you produce on their behalf. So some people consider it unfair, but not really.
No. So you touched there about upon the fact that there's different things in different jurisdictions.
Hmm.
So when you're doing your plan, how far sort of do you normally would recommend people would go regarding to making sure things are protected internationally?
Well, there's a complicated, not complex path between the filing of an idea through to protection. I think the key thing to remember is that you can start with a seed of an application, and that application can be divided, it can be diversified through uh, international filings using the Patent Cooperation Treaty, or you can have a bundle of rights within a European application, which will split into national applications. There are various ways and means in which you can have applications running in parallel. But I think the key thing for inventors to understand is that patents are ultimately a national right. So you're looking to take that first application that you have, follow the smoothest process, fastest process, most cost efficient process according to what you need to end up with a national patent or a national trademark within the country that you wish to seek protection. So just to be clear, because I take a lot of this for granted. If you have a UK patent and a UK trademark, you can't enforce them in France. It seems an obvious thing to say, um, but I've experienced a lot of misunderstanding with lay inventors in the past. You get a patent granted in the UK and they say, okay, so now I can go and exploit this in China, and you're like, no, sorry. Um, and I think it comes back around to why we focus on this kind of whole idea to commercialization thread. If you follow the process, whether it's patents or trademarks, and there can be multiple threads within a sophisticated business, multiple applications, multiple projects, but there needs to be a clear understanding, a kind of rationale from the very beginning of what you want to do, why you're doing it, how you're going to achieve that.
Super. We've had a first question come in from Bethan from our team. So thank you, Bethan, for watching live. Hi, David and Nikki. What types of IP do businesses most commonly overlook?
I'm going to say it's a great question. The obvious one is trademarks, because people will just assume it's my name or I've registered the name on at company's house, so I'm protected. But that's not the case. You really need to register that mark. So that's an obvious one and an easy one for any business. I think the challenge in technical related businesses where there is a technical solution to a technical problem is that and most of the inventors that I meet are exceptionally intelligent, exceptionally focused, but they're so specialized and so engrossed in their field that take everything that they do for granted, and they just assume, of course you would do this, and this is obvious. But quite often they're very innovative in what they've determined. So the test I always encourage them to apply is considering in their process of developing a product, what problems have they faced? How difficult have these problems been to overcome? What new things have they had to create that haven't existed previously? And when you get these kind of new aspects that are significantly advantageous, or that are allowing you to make progress where previous there was some kind of barrier, then those are kind of green flags for seeking patent protection. It's the most obvious thing to do, but unfortunately sometimes it doesn't come out because people take it for granted. That's the risk.
So thinking about something that's timely for this week, so we've got the UK's got a huge delegation in China at the moment, and what is there's a common thought of if you utilize China to produce a lot of your goods, that you are then at risk of your recipe or design or whatever being copied. Is that really true, or is that just a bit of a scare tale? Is there any way that you can protect yourself if you are producing, whether it is in China or other places, you're producing your goods?
I think I'll answer that in two stages. One is to consider what's likely to happen if you don't register and protect your IP, whether it's your name or the technology that you've developed. It doesn't matter which country in the world it is, or whether it's in the UK, but someone can copy you. They can take your product, reverse engineer it, reproduce it better, more efficiently, and take advantage of that and outcompete. I think the second part to that is in relation to China in particular. The probability of someone copying you in China is significantly higher than it is elsewhere. There seems to be a kind of, certainly in the UK, a cultural reservation to copy someone. Oh, I can't do that because that's not fair. Life isn't fair, and certainly not fair in China. They will copy you in a heartbeat. However, on a positive side, registrations in China are worthwhile. I can't stress that enough. Capital letters. Their patent system is based on the European system. Their court system has been mature and competent in determining and assessing IP cases for at least the last 15 years. So if you are going to protect, get it on file. It can start in the UK, and through this relatively complicated path between a filing in the UK and a national filing in another country, China definitely should be on the radar. For all of my clients, I recommend Europe, of course. UK, Europe, US, and China are the key markets. And if you don't protect there, you're a fool. If you're never going to go to China, fair enough, but bear in mind that they make and they export. So keep it sensible.
So we've had another question, this time coming in from Tim. So thanks, Tim, for your question. Are IP related disputes a common occurrence?
Yes. I think the caveat to that is that no one really wants a fight. No one wants to go to court. And if a client or someone who wants to enforce their rights, or someone is being threatened with an infringement action, my advice is always mitigate, discuss, and avoid. Assess your situation. It almost comes back to this mapping, planning, building type philosophy. What response are you going to take, and what do you expect in return? There's a great question, and the trigger usually occurs, these disputes usually occur when someone is diminishing or taking advantage of someone else's business. So if you are copying, or if you have been copied, the trigger for you to take action is really when it's doing a harm to your business. So some monitoring can check for that. So if I had a business making pens and there was some big competitors that I wanted to stop because they would threaten my business, I would take action. I would do it strategically. I would discuss letters before action, seek proper legal advice. If it happened to be a small customer that might be making a few hundred a year and the profits might be 10 to 50,000 pounds, I probably wouldn't bother. It's unlikely to harm my significant business. So really the measure is always what's the damage that it's doing to you, and then react accordingly. I had many years ago, I got introduced to a new client. We're still in touch and we still meet for lunch, 15 years later. And he had been making a small smoke filter for laparoscopy. In his laparoscopic procedures in an operating theatre, they put the tools inside, they inflate you like a balloon so that they can operate inside the cavity of your body, and then they cut and they burn and everything. And all that gas is vented, and the last thing the surgeons want to be breathing in is this harmful air. So there's an exhaust port with a tiny little filter. And this chap was making and selling these for almost 15 years before someone came along and said, please stop, with absolutely no caveats, no please stop if or license or anything. Very confusing. My client had been licensing years before. The IP had changed hands and it ended up in the hands of a significant company in the US, a medical device specialist. And we eventually got to the bottom of the aims of that company. They wanted to increase their own manufacturing throughput. They didn't really want to stop for monetary values. They just wanted people off the market. So we came to an agreement where my client ended up buying products directly from them, overcoming the licensing problem. There's always a way around, but ultimately always avoid court if you can.
Absolutely wise, very, very wise advice. Okay, that's there's been a lot to go through today. Lots of really good practical advice, process to go through, the different scenarios. So really, really useful. Thank you so much for your time today, David. And for somebody who's got a question that they didn't want to share, or just want to have a discussion regarding IP, where's the best way to contact you?
David.stanners@50-ip.com, or check me out on LinkedIn. You should find my contact details there. And perhaps you can share my email in the LinkedIn chat or in the tail end of this video.
Yeah, I'm just putting it. So it's david.stanners@50ip.com.
Now I'm going to check that myself because I'm down.
So I don't want to put it on the screen.
Yeah, that's the one.
Okay, fabulous. I'm going to pop it on the screen so that anybody can see that. Fantastic. Great. Well, thank you so much. That was really useful. Have a wonderful weekend. Thank you, everybody that listens live. Anyone that is watching later on YouTube or LinkedIn, thank you so much as well. We will be doing these monthly in this year, which year is 2026, just in case you're watching it very far in the future. And we are so we will be, I'm thinking it's probably going to be an ISO related one in February. We will generally be live on the last Fridays of the month, but in February, we actually have one of our live business blueprint seminars. So I can't be in two places at once. So we'll probably be on the 20th in February, because we're on the 27th. We'll be at Goring Street Golf Club talking about systematizing your business. There are lots and lots of events that Goring Accountants are running this year. Last count is going to be over 30 if you combine the in-person and online ones. So please do always check the Goring Accountants website under events to see what the latest ones are. But just so you know, the next one, a quarterly networking event, is at Pangbourne College on the 17th of February. And as I said, the next business blueprint seminar is the 27th of February. So I'd love to see some of you there. That would be fabulous. But for now, thank you once again to David. That was absolutely fantastic. And have a wonderful weekend, everybody. Thank you.
Thank you.
Here we go.
Bye.